Party will have 15 minutes in which to present their case if you're the appellant, and you have up to 5 minutes for rebuttal. If you wish to retain some of that time, let me know when you come up to the podium. I'm keeping track of the clock and will keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read your briefs and we're ready to proceed with the floor.
Thank you, Your Honor. Good morning. We get you just before lunch, right? Yeah, that's great. Steve Bailey for Windward Enterprises. I reread my brief this morning. I think it sets forward the argument pretty clearly. I'm certainly available to answer questions. I think as to the first assignment of error, what I would like to say is we have a system in the rules set up that is designed to kind of keep an eye on juries. And what I mean by that is that some of the concepts that we try in front of juries are complicated and difficult, and jurors are almost always lay people. And so the system of summary judgment, directed verdict, motion for a new trial are all part of a system that is designed to kind of look out for the jurors. So that when we get a case where reasonable jurors could not reach this conclusion, we dispose of it by summary judgment or directed verdict. When we get a case submitted to a jury and the jury verdict comes back and it is, we're looking at it and saying, wow, it doesn't make any sense, that is when Rule 50 and Rule 59 comes into place. I think they noted in their brief that I conceded that Rule 50, that you could not overturn the judge's decision on Rule 50, and I did. And that somehow that meant that I was conceding Rule 59. They didn't really follow that argument, but I'm sure the court understands the distinction between the two is that Rule 50 does not allow a judge to substitute its judgment for the jury's on the basis of a weight of evidence, whereas Rule 59 does permit the judge to grant a new trial on the basis of weight of evidence. So our position is pretty clear, okay? If you say as a jury that you took our property and you converted it and you find in our favor for conversion, and all the evidence in the case presented gave that value, that property value, both the other side's and ours, widely different value, but value nonetheless, you can't then say we weren't damaged and we have zero damages. I think that adding to that fact is that in this particular case, there was a debt owing upon that property that was converted. We owed a debt on part of the property that was converted. And the jury ordered that we pay that debt. So the jury says, yes, they converted your property. Yes, you have to pay them the debt for that property that they converted, but your damages were zero. And I think the jury clearly lost its way. And that's what Rule 59 is for. That's what it's for. Whether the jury thought, well, you know, if we weren't awarded damages, we would get the property back, or something else, I obviously can't speculate. It doesn't matter. It doesn't matter because the rules don't allow us to speculate anyway. So I'll address in maybe 5 minutes, if I have that much, what he's going to say about set-off. But I'm going to pass that on for now. Real quickly, second assignment of error. We prevailed against Mr. Weber in this case. We prevailed. There just isn't any other way around it. He sued us on a dram shop action. We won. There's no way he shouldn't eat some of these costs. Those costs were significant in this case. And we also prevailed on the conversion claim. notwithstanding the verdict, the jury didn't give us any money, we prevailed. We were a prevailing party. There were 5 things that went to the jury. We won 2 of them. And there's no way we should get stuck with all of the costs. There's case law that's in my brief, makes it clear that the court can apportion the costs, and it should have. And it didn't. There was the whole business of the journal entry being submitted to us for approval. It wasn't. It was sent to us the same day it was sent to the court. The court just signed it. I think you should overturn it. And the last sign of error is about this security agreement. And I think it's a really important issue. I do. I sign an agreement with you, and I give you to buy some stuff, and I pay you part, and I owe you part, and I give you a security agreement, and I pay it, and I pay it, and I pay it, and I pay it, and then one day, this company comes along, happens to be common ownership, of course, but for us lawyers, it's a separate entity, right? And so this company comes along and says, I'm going to pay off that debt that this guy owes you. I'm going to pay it off. And they do. They write a check, pay it off. It's gone. And now they come over to us and they say, now we paid off your debt. We want you to agree in this lease agreement with us that debt you owed to us now. And we go, yeah, okay, you paid it off. That's all right. We'll owe it to you. And we sign. Nobody ever says, and we want a security agreement. The court treated that security agreement as if it were assigned. It was not assigned. There was no assignment. Why is that important? Why does this matter? Why, if it is error, isn't it harmless error? Because they hammered at the jury, in this case, that our moving the equipment from this location violated the security agreement, which was then a violation of the lease. And the jury found what? That we violated the lease. The jury found we violated the lease. It is extremely easy in reviewing the record to conclude that it was the security agreement that allowed the jury to find that. So it should never have been admitted. Now, I might as well bring this up because they're going to bring it up and they're right. We're going through all the exhibits at the end of their case, and we come to that exhibit, and he says, is there any objection? I said, no. It's true. It's absolutely true. I screwed up. But it was manifest in it was manifest in the record that we were objecting. Manifest. We did object. And there was a long discussion with the court, and the court made it clear it was going to admit that exhibit. That decision was already made before that end of the case litany that we go through. So, yeah, okay, I screwed that up. No question about it. I don't think that should be dispositive of this. We made it clear we were objecting to it. And the issue should be decided on its merits, not because of a slip of the tongue by me. No, unless you think so. And if you do, it's your court. That's all I have. Any questions? I'll be glad to take.
You have 5 minutes for rebuttal, Bill.
Thank you.
Your Honor, Your Honors, good morning. My name is Eric Minchner on behalf of Valley City. The arguments that are made in this case by appellant all require the court to speculate, one as to the jury, one as to the judge, and finally, frankly, speculate as to what would have happened if, in fact, the court had not allowed the security agreement into evidence. With regard to the extraordinary relief that's being requested to overturn a jury's findings on damages, there are only a couple of occasions where that's appropriate, where jury passion or prejudice is so disproportionate as to shock the conscience or against the weight of evidence so much to create a manifest injustice. And there's just simply nothing like that here. As you noted, I'm sure as in our brief, the jury only awarded us in this case $39,000. We asked for well over $44,000 plus another $10,000 for breach of contract. When you add all that up, what that means is there's a $16,000 difference between what we asked for and what the jury awarded us. That certainly is not something that would shock the conscience. That shows they were exercising their discretion as to which party would be awarded what amount of damages. Unlike the case that is cited by appellant, where the court said, no, if you find there's a conversion claim, there's got to be at least some damage. In this case, there were no two parties fighting against each other trying to both claim damages. Here, I think it's pretty clear what happened is the jury simply did a set-off where they decided, okay, you had conversion, who knows what they value that property as, but whatever damage you had is certainly not as great as what was occurred to the appellee in this case, and they basically made a determination. And if you look at the difference there, $16,000, that's about roughly around what our experts said the value of that property was. Now, our jury is artful in that they're determining, well, you're going to set it off based on, this particular count versus that particular count. No, but we're not supposed to peek behind the curtain to see exactly how the sausage is made. We're supposed to see if there's evidence in the record that would support their verdict. And frankly, there's more than enough evidence in this case to support their damages finding based on the evidence that was presented. Either way, appellant speculates, well, maybe it was because they thought he was going to get the property back. There's no evidence of that. The jury was never polled. They were never asked anything with regard to something that the appellant thought was on its face improper. And so any ambiguity, in a sense, is created by their failure to even look into this issue or to talk to the jury. But either way, I would agree with them. It doesn't really matter the reason. The question is the evidence sufficient to support the jury's findings in this case, and I think there is. Particularly because at one point, appellant talked about asking the owner, any of the property you want still, and he said no. Then the jury may have just determined he converted at one point because they kept it, but then he abandoned it. We don't know what their rationale was, and that's really not for the court to speculate on. As far as court costs are concerned, the standard is abuse of discretion. What the appellant has done is try to turn that on its head and say, well, if the court could have done something, it must have done something. When there are, in order to prove that the court's assessment of costs is improper, you have to find that there was no rational basis, that it abused its discretion when it decided that the party that received the lion's share of the award here got actual damages, and won 3 of the counts should not be the one that's actually required to pay court costs. The court here made the determination completely within its discretion that it was going to assess court costs to the person who brought the lawsuit, but then lost the main issue. And frankly, it's not even clear that the court could have awarded court costs in a proportionate way, because here the plaintiff lost on the main issue in the trial. The dram shot claim, and you can look in the record, it's a sideshow. It's a minor thing that took maybe 2 witnesses. The lion's share of this 4-day trial was on this property, both the property with regard to the inside of the business, as well as the lease for the property where the guts of the business is being run. That's where the damage is being sought was, that's where the main issue was in this case. Yes, he won on the dram shot claim, but clearly lost as far as the amount of damages. And there are courts that say that you can base your decision based on who got the most damages, and that's within the discretion. And here, that's what happened. And with regard to this issue about letting the security agreement into evidence, one, he did waive it, as he conceded. There's no plain error here, though, because the court made very clear why this agreement would be, security agreement would be admissible evidence, because according to the court's own ruling, there was no novation here. That security agreement continued on. And because of that, and that was a decision of the court. Funny enough, it wasn't something the appellant actually raised on appeal. Don't know why, that was a major part of his case, but he chose not to raise that issue. He's trying to, through the back door, raise that issue by saying, well, you shouldn't have been at the security agreement. But even if you believe that the novation for some reason had occurred, and that was probably before the court, the trial court lists a lot of reasons why that isn't the case, and why there was no novation here, so the security agreement continued. More importantly, the appellant himself admitted under oath that he thought the security agreement was still in place when he took the property. But finally, even if you thought of all those things and said, but we still think they should have admitted it, it's harmless because there were multiple reasons that the lease was breached in this case, including the state of disrepair that the property was kept in, and the photographs were rather explicit in showing how bad this property was maintained, and that was another breach of the lease. And so any error would have been harmless if, for some reason, all the other reasons that I've mentioned were not sufficient. That's all I had, Your Honor.
Thank you. We really have 5 minutes, sir.
Thanks. That sideshow comment would be a mite sight more convincing if it weren't coming from the guy who prosecuted that cause of action. I didn't think it was a sideshow then, I guess. We won, period. Mr. Weber lost, period. I don't know how the court cannot find us to be a prevailing party in regard to that. I don't know how we don't get credit for court costs. The novation argument, sometimes after trials is over and I go back and I think about things and I read the record, I think of better arguments than I had at the trial. And this is one of those times. In retrospect and looking back on it, I'm not sure it was a novation. Novation would be between the same two people. And I think that was the failure of my argument. Hat Trick was the name of the company we bought this equipment from. Hat Trick is the name of the company we owed money to. Hat Trick is the name of the company that we gave the security agreement to. When that all changed, our new agreement was not with Hat Trick. That would be a novation. Our new agreement was with Valley City Development. It was a brand new agreement. They just paid Hat Trick off. There was no strings attached. There was no assignment. They didn't say to Hat Trick, you're assigning this debt to us. We just agreed to sign a new contract with Valley City, leasing the property from them, and paying them back the rest of the money that we had owed Hat Trick. There was no security agreement as part of that agreement. It wasn't a novation. It was a new contract. Talk about speculation. They want to speculate that because the jury gave them $16,000 less than they were asking for, they must have been offsetting the amount that their experts said our equipment was worth that was converted. Well, that's just not true. Their experts said that equipment was worth 10 grand. The amount that the jury decided they weren't entitled to was 16 grand. Where did the other 6 go? And besides the math not working, it's just not the way that it should work. And it's in the hands, as I started, of us as lawyers and judges to monitor the juries and make sure they stay within the bounds of the law. It isn't within the bounds of the law for them to make that set off. That's not their job. Decide this issue, decide the damages. Decide this issue, decide the damages. No one ever in the instruction says, oh, and if you figure out they both owe each other something, you can set it off. They didn't do that because math doesn't work. But it doesn't matter. Doesn't matter what they did. They found conversion, the evidence, all of it supported a value. All of it. And for some reason, they award 0. That's what our jobs are as lawyers and as judges, is to say, okay, jurors, we got you. You found conversion, that's good. Yeah, but you kind of made a mistake over here. And so then we're going to give you another shot. We're going to give you a new trial on that issue. And we're going to give you another shot. Thank you.
Thank you both for presentations today. The court will take the matter under advisement and issue a written decision, which will be on both sides, as well as posted to our website and at the Supreme Court. Court is adjourned.
Thank
Thank
you.
you, Your Honor.